Public land use control is given to the government through police power, but there's another common type of land use control that you'll certainly run into during your work called private land use control. Private land use controls are most frequently associated with homeowners and condominium owners associations, where the builders or developers place specific restrictions on the property. These restrictions are generally known as covenants, conditions, and restrictions, or CC&Rs. They can also be referred to as bylaws, house rules, or master deeds. These are formal, recorded private limitations on the use, appearance, and maintenance of real property within the designated area. Essentially, all common interest properties or places within homeowners associations, such as condominiums, cooperatives, and gated communities, use CC&Rs. Some of the rules that may be stipulated by CC&Rs include things like house color, landscaping or yard use restrictions, allowing or prohibiting home-based businesses, limiting RV or other street parking, and noise restrictions. For example, some CC&Rs may broadly establish lawn maintenance standards or house paint color choices. Others may be more specific in their restrictions, such as whether or not residents may use a pool cover, whether they can park an RV within visibility of the main road, or what breed, size, and type of dog is allowed on the premises, if at all. One core element of CC&Rs is that they can only be created by agreement, and CC&Rs that last more than 1 year must be put in writing. For example, property owners in a neighborhood may enter into CC&Rs restricting the involved parties from subdividing their land. All of the affected owners need to expressly agree to the CC&Rs. Once agreed to, CC&Rs are legally binding, so if one of the property owners signed the CC&Rs but subdivided their property anyway, the other property owners could sue for breach of contract and seek monetary damages or other remedies. A review of CC&Rs is typically part of a real estate sale and should not be overlooked. It's important to make sure that restrictions on a piece of property fit in with the prospective buyer's expectations. However, determining the legal effect of specific provisions is considered the practice of law, and therefore beyond the professional scope of a real estate licensee. If a client has specific questions regarding the legal rights and remedies conferred by CC&Rs, you should refer them to an attorney. Another type of private land use control is a deed restriction. A deed restriction is a private agreement listed in the deed to a property that restricts the use of the real estate in some way. Often developers will restrict the parcels of property in a development to maintain a certain amount of uniformity. A deed restriction limits the use of land but does not limit the owner's ability to transfer or sell the property. It's important to note that restrictions which clearly go against public policy are unenforceable. For example, any restrictions that go against fair housing laws, such as limitations that are too restricting to certain populations, would be unlawful. The restrictions within a deed are meant to control the use of the property, not who can live on the property. Restrictions transfer with the deed and generally can't be removed by new owners, except through further legal negotiations. Deed restrictions are generally enforced by local law enforcement. Each home or lot owner in a development under deed restrictions has legal standing to apply to local law enforcement or bring suit in court to enforce the restrictions. These homeowners or lot owners can also lose their right to request enforcement through the legal concept of laches, which means an unreasonable delay in asserting a right. For example, if homeowners in a neighborhood covered by deed restrictions ignore a new house being built in violation of those deed restrictions, and they fail to bring suit against the builder or homeowner within a reasonable amount of time, such as while the house is being built, they might lose their right to bring suit forever. Deed restrictions can be altered in some circumstances. If it's necessary to obtain an alteration of a deed restriction in order for a home or lot owner to use a property for a specific purpose, there are two means that can be used: waiver or judicial. For the use of a waiver, the home or lot owner will need to have every other property owner under the restriction, the mortgage lender, and the original developer notarize a document granting the waiver. This may be more difficult for a property owner to obtain if there are a large amount of properties under the same restriction. Therefore, especially in a large restricted area, a property owner may turn to judicial recourse. In this case, the owner files a lawsuit to obtain a judicial ruling that declares the restriction void. In this way, they are not required to deal with any of the other property owners. Understanding private land use controls for a piece of property is just as important as understanding public land use controls, as both can affect a buyer's choice when they're looking for a property to purchase. It's an essential part of your job to ensure that all of the land use restrictions, both public and private, have been explained to the potential buyer so that they can determine whether or not the property is suited for their specific needs and desires.